Hello, my name is Juan Peña. I'm a human rights specialist for the Kentucky Commission on Human Rights. Thank you for choosing to watch this presentation titled Equal Employment Opportunity Laws in Kentucky. The Kentucky Human Rights Commission would like to thank to all the coordinators of this Lexington Bluegrass Area Minority Business Exposition for giving us the opportunity to speak or present about the Commission. This presentation has three parts. One, I will introduce, given a brief introduction about the Kentucky Human Rights Commission. And two, I will dive into the laws that makes unlawful in discrimination in employment. Three, I will explain the complaint process here in the Kentucky Human Rights Commission. As you may know, that the Kentucky Human Rights Commission is a state government agency that enforces the Kentucky Civil Rights Act, KRS 344. The commission has 11 board members known as the commissioners, and they are appointed by the governor of the state. And the commission or the board of commissioners meet once a month. They meet to hear and vote or approve the complaints received and investigated and recommended by the staff of the Kentucky Human Rights Commission. And another statutory authority that has the commissioners is to initiate complaints. In order for the Kentucky Human Rights Commission to investigate a case, we must have a complaint and we must have a complainant. So if we receive a complaints and the complainants are reluctant to come forward to file complaints, the commission has the option to initiate the complaint to be able to investigate. The commission is divided into 5 parts. We have the executive director, Mr. Terrence Sullivan, and we do have the enforcement unit. This is the place where all the investigators investigate cases. And we have the mediation unit for any complaint related to employment and public accommodation. The respondent and the complainant are given the option to mediate. I will be using these two terms often. Respondent refers to the company or employer that has been filed a complaint against, and the complainant is the person who files the complaint. And so then we have the legal unit. This is the unit that review the legal cases and also is there to provide legal counsel to the rest of the staff. Then we have the last unit is the education outreach unit. This is where I come from. And our responsibility here is to go out in the community to give trainings about the different areas that we cover at the Kentucky Human Rights Commission. The Kentucky Human Rights Commission is a neutral agency. We don't work for the complainant nor for the respondent. All the complaints are investigated impartially. So the main work of the Kentucky Human Rights Commission is to enforce the Kentucky Civil Rights Act. For any one of you who likes to read laws, this is the reference, KRS 344. So under the Kentucky Civil Rights Act, there are 4 specific areas where we have a jurisdiction to receive and investigate complaints of discrimination. One is in employment, housing, and public accommodation, and financial transactions. So for today's presentation, we're going to talk about the laws pertaining to equal employment opportunity. So the laws prohibit discrimination against any person on the basis of age, color, disability, national origin, race, religion, sex, pregnancy, and smoking. Retaliation is also not a protected class, but anyone can file a complaint on the retaliation, but I will explain in detail later on. It is extremely important to remember this list of protected classes. Here at the Kentucky Human Rights Commission, we receive endless of complaints of different forms of discrimination. But if it's a discrimination that's not related to one of these protected classes, therefore, it's not an unlawful discrimination or it's not a case that we can receive and investigate. So it is extremely important to remember these protected classes. I wish I had more time to talk in detail about these protected classes, but I would just mention a few of them that I believe that's extremely important. One is the age. So age, anyone who is 40 and over is protected under these equal employment laws. I will give you just an example. For example, so if you have a company who terminates the employment of someone who is 65 years old, but hires someone who is 63, the difference of age there is not significant. Therefore, we might not be able to file a complaint. But if you have someone who terminates a person who is 65, but hires someone who is 42, and the employer might argue that the person who is 42 is also a protected class, well, we see a big gap there from 65 to 42. So that might establish a prima facie for us to file a complaint of discrimination. And disability, this is the definition that comes from the laws. And so there are three. The definition is a person may be disabled if he or she has a physical or mental condition that substantially limits a major life activity such as walking, talking, seeing, hearing, or learning. 2, a person who might be disabled or if he or she has a history of a disability. So anyone who might have had cancer, but that person is already free of cancer, that person is still, it's protected. A person who may, also 3, a person who may be perceived to be disabled. So any person who believes to be disabled, but is not disabled, that person is protected as well. Other areas that I would like to kind of spend some time is under sex. So in the sex, it refers to the gender of the person, but under sex, is sexual harassment is also a form of sex discrimination, and also any discrimination on the basis of sexual orientation and gender identity is also a form of sex discrimination. And lastly, to treat someone different because that person is pregnant is also a form of sex discrimination. So these are the areas under pregnancy. So anyone who feels she feels has been treated differently because of she is pregnant, that person can file a complaint on the basis of sex. Now, I have been with the commission for close to 20 years, and we still received quite a few complaints related to pregnancy. And I believe that our Kentucky legislatures were aware about this situation, that discrimination against women because they're pregnant was prevalent. They passed a new law in 2019 and it became effective on June the 27th. The law is known as the Kentucky Pregnant Workers Act. This specific law highlights in detail the responsibilities of an employer. So in this law, it says that an employer must make a reasonable accommodation to any employee who is pregnant and cannot discriminate against any person because of their pregnancy, childbirth, or related medical condition. And also under this law, it requires employers to provide a location, a privacy for a person who wants to express milk for their loved ones. So again, that law is known as the Kentucky Pregnant Workers Act. So if someone feels discriminated against because of pregnancy, they can file the complaint on the basis of pregnancy and also under sex. The difference here is that under the pregnancy or the Kentucky Pregnant Workers Act, that the employer must have 15 employees or more. But if a person files a complaint under sex, the employer needs to have only 8 or more employees. Smoking. So in Kentucky, an employer cannot inquire the smoking status of a person or someone who's applying for a job. And I will give you an example about this. A few years ago, I received a call from a complainant, and the complainant was shared with me that this the employer did not provide a place for to smoke, a designated area to smoke. Smoking doesn't mean that an employer should provide a designated area for smoking, but what it means, they cannot treat employees differently because of their smoking status. But this particular employer since the employer did not have a place for the employees to smoke, these employees went to a public area or the street to smoke, and the employer was concerned about the liability. So this employer required these employees to clock out and clock in. On the other hand, there were other employees who went to a nearby convenience store for a snack, but these employees were not required to clock out or clock in. So if the employer was concerned about the liability of these employees, the employer should have asked all employees to clock out and clock in anytime they went out the premises of the employer. So again, there's a different treatment right there. Retaliation. So retaliation is unlawful when an employer takes any action, negative action against the employee. But the retaliation is unlawful under the Kentucky Civil Rights Act only if the employee complained about a complaint about a possible unlawful discrimination. In other words, that the employee brought to the attention to the employer about a discrimination on the basis of a protected class. Or if the person or the employee filed a complaint with either state or federal government agency about a discrimination. And also, an employer cannot retaliate against anyone because the person has participated during an investigation of a complaint of discrimination, or the employee or the person has refused to carry orders that are unlawful practices under the Equal Employment Opportunity laws. So in Kentucky, trying to remember here, in Kentucky, sexual orientation and gender identity is not a protected class. However, based on the U.S. Supreme Court decision on June the 15th, 2020, it ruled that discrimination based on sexual orientation and gender identity in employment violates the Title VII of the Kentucky Civil Rights Act of 1964. So they expand the definition or define or clarify the definition of sex. So therefore, to treat someone differently based on their protected classes or gender identity, it becomes an unlawful discrimination on the basis of sex. Unlawful harassment and sexual harassment in the workplace. So any harassment related to a protected class. So for example, someone who makes fun of someone because that person comes from other country, that will be a harassment on the basis of national origin. Or someone who makes harassment against a person because of that person's disability, that will be a form of harassment and unlawful harassment. So again, it's unlawful harassment. It's a harassment based on a protected class. So let me give you an example about harassment that might not be unlawful. Let's say we are in Kentucky. So people are very serious when it comes to basketball games. So if you're in favor of a UK, then you have someone else who's in favor in the University of Louisville basketball team, and they just tease each other or harass each other because of their team. That will not be a unlawful harassment, okay? Again, it has to be related to a protected class. Now, sexual harassment. It's unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature, okay? So there in the sexual harassment and any other form of unlawful harassments, there are two terms that we used. One is severe and the other one is pervasive. So severe, it means that the incident itself is so pervasive. In other words, that the person actually touched or close to assaulted to a person. So if that touching to without the consent of other person, that will be a severe form of harassment. A pervasive. Pervasive might be just a small comments, but again, there can be sexual comments or any other form of comments that imply the appearance of the victim. And it happens over and over and over, and start to create a very hostile work environment and start to impede the work of that employee. So that's the a pervasive form of harassment. So in any harassment, and especially in sexual harassment, so a victim can be either sex, and the harassers can be either sex as well. And the harasser can be a supervisor, it can be a coworker, it can be a manager, it can be the owner of the company. Again, so if the harasser is an employee, it's a coworker and does not have any position of authority in the company, the employee or the victim must inform the employer about that sexual harassment, okay? And if the employer doesn't take any action, then the employee can come forward to us and file a complaint of sexual harassment. Now, if the harasser is a supervisor or manager, or then the supervisor or the manager represents the company. So if a complaint is filed against the company, and if the harasser is the supervisor or manager, the company is liable for the actions of the supervisors and managers. So it's important to remember that. So it's the responsibility of the employers to educate their employees, especially their supervisors and managers, about unlawful harassments in the workplace. Also, the employers are responsible to protect their employees from any sexual harassment or any other form of unlawful harassment from an outsider, for example, from a customer. So if you have for example, if you have a grocery store and you receive clients coming to the store, and you might have a client who harasses an employee, and the employee complains about this harassment, the respondent must take action to protect the employee. Otherwise, the employer is liable for that harassment or lawful harassment. Reasonable accommodation for qualified person with disability. That's another area that we start to see a lot of complaints in it. So we read the definition about the disability. So any person, including people with disability, must have the same opportunity as anyone else to work, as long as that person is able to perform the main function of the work, or the main function of the duties of the job, with or without a reasonable accommodation. So if the person can do the work but requires or needs a reasonable accommodation, the employee must make that request of reasonable accommodation, as long as the requested accommodation is not or doesn't impose or create an undue hardship for the operation of the employer's business. So, and some of the accommodation can be provide any equipment, device, or provide any alternative if the employer requires employees to take any exams, or any also provide trainings, for example, someone who cannot read, or someone cannot hear, then the employer is required to provide any other forms to ensure that that person with disability is able to receive the training and understand the policies. And one question that we receive a lot is that if a person or an employee who is associated with someone who is disabled, in other words, that the employee has a family member who is disabled, can that employee request a reasonable accommodation? The answer is no. The employee must be the person who is disabled in order to request that reasonable accommodation. Other area that we have seen is that if you have a person who is disabled, who works full-time, and for some reason the disability has progressed and prevents that person to work a full-time, and the doctor has advised to work only half-time, or the employer is not required to create a new position, a part-time position for that employee. However, the employer is required to give the opportunity to the employee for a part-time position if there's an opening or when it becomes available. So again, the employer is not required to create a new position for that particular employee, unless that employer provides flexibility for other employees. Therefore, then the employer might be required to create or make that same flexibility for the person with disability. Now, so who is covered under these equal employment opportunity laws? So employers with 8 or more employees, employment agencies, licensing agencies, labor unions, any company, entities that publish, print, or post employment advertisements. I'm going to go in details about this area, okay? So any employer with 8 or more employees are subject to these equal employment opportunity laws. So anyone can file a complaint against an employer as long as they have 8 or more employees. But when it comes to a complaint on the basis of a disability and pregnancy, the law requires that the employer must have 15 or more employees. And the definition of employees means a person who has 8 or more employees within the state in each of the 20 or more calendar weeks in the current or preceding calendar year. Again, that's the definition of the employer, of an employer of 8 employees. So employers cannot treat differently to anyone on the basis of the protected class that we have learned. They must provide the same opportunities, same benefits. They cannot take into account of any of the protected class to make a decision. Employment agencies. It is unlawful for an employment agency to refuse to refer for employment or to treat someone differently on the basis of their protected classes. Licensing agencies. This can be any state government or any contracted agency who issue any license for a career to practice. For example, attorneys who might need a license to practice, that licensing agencies cannot refuse or treat that person, the applicant, differently because of their protected classes. Labor unions. It's unlawful for labor union to represent or discriminate against a person because of their protected classes. Advertisement. Again, it's unlawful for an employer to order to be published any discriminatory act or publish any ad that might imply a preference of a person. So again, they cannot place or print. They cannot, any company dealing in that, including published or internet-based or all the social services available in the internet, cannot print or show any ads that gives a preference to a specific class of people or based on their protected classes. Of course, under the law, there's some exemptions. This can be there's a lot. It really depends, but in general terms, a religious corporation who employs people to carry their to talk about their religion and teach their religion, again, they are exempt from these equal employment laws. Now, so when we receive complaints of discrimination, this is the list of questions that we ask. First, is the caller or is the complainant alleging of a complaint related to a protected class? So if it's yes, then we ask the next question. Does the employer have 8 or more employees, or 15 or more if the case is related to disability or pregnancy? Did the incident occur within the 180 days? This we call the statute of limitation. It is extremely important for complainants to know this. So after 180 days, the complainant has another 120 days to file a complaint with the Equal Employment Opportunity Commission. This is the federal government agency in charge to enforce the Equal Employment Opportunity laws, known as the EEOC. So the EEOC stands for Equal Employment Opportunity Commission. And for any complaint filed at the Kentucky Human Rights Commission and the employer has 15 or more employees, the complaint is due file. It's also filed with the EEOC. In order for the Kentucky Human Rights Commission to receive the complaint, the incident might have happened in the state of Kentucky. We receive quite a few calls from other states. For example, we're based here in Louisville, and across the river, Ohio, people complain. Even if the complainant lives in the state of Kentucky or live in Kentucky and work in Indiana, those type of cases we cannot take. So the incident must happen in Kentucky in order for us to have the jurisdiction to file the complaint. Also, we ask the question, was there an adverse action or pervasive action taken against the complainant? If not, then we cannot file a complaint. Now, the complaint process, let me look at my time because I only have 30 minutes to present. So when a person feels that she or he has been discriminated against because of one of their protected classes, that person has the right to call us and file a complaint. So we receive the complaint, we interview the complainant and gather all the information that we need. And if we establish jurisdiction and establish prima facie, then the commission writes the charge and the charge is sent to the complainant for his or her signature. Our statutes require that the charge should be notarized. Once the charge is signed and notarized, they send back to the Human Rights Commission, and the commission will file that complaint. And when the commission files that complaint, or when we receive that charge, that's when the time of the statute of limitation stops. So this is extremely important, because one thing that I have learned, that a lot of the complainants call and they don't have all the information that they need to have for us to file a complaint, and they don't call again, and they switch phones, and we cannot find that person, but 3 months later or 5 months later, they call and check the status of their complaint. Well, to start with, we never had a complaint. So again, it's important to know that the complaint is filed only if they have signed and notarized the charge and sent back to the commission. So once the commission receives that charge and file it, the commission serves a copy of that charge to the respondent. In employment, the respondent has 20 days to respond. And often the respondents request for an extension of time. So it can pass 30 days without having a response yet. Once the commission receives a response from the respondent, then the commission makes a decision to go with the mediation or go directly to the enforcement unit. As I mentioned earlier, that any complainant in employment and also in public accommodation, the respondent and the complainant are given the opportunity to mediate. So when the charge is received and sent to a copy to the complainant, along with that package, there's a mediation form. So if both parties pick or select to mediate the complaint, then the commission finds a date to mediate the complaint. But if not, that complaint goes to the enforcement unit, where an investigator or an enforcement officer will be assigned to the case and do a thorough and impartial investigation to see if in fact there was a unlawful discrimination. So the mediation, any outcome or if there's a mediation, then the mediation, the terms and the conditions of the mediation is private. The commission doesn't know the terms of the condition of that mediation agreement. Now, if the complaint is sent to the enforcement for investigation, the enforcement officer may encourage both parties, the complainant and the respondent, to conciliate the complaint. And the conciliation is similar to the mediation. The only difference here is that any agreement that comes from a conciliation, that agreement is subject to open record request, public open request. In other words, that the public or the commission knows the terms and the conditions. Two, that the commission is also part of that agreement, and the commission might impose additional conditions. For example, the commission might ask to receive a report from the complainant, I'm sorry, from the respondent for 2 or 3 years. Now, if there's not a conciliation and the enforcement officer continues its investigation, so there are several outcomes in the investigation. One, if they finish their investigation and they issue two possible outcomes. One is the no probable cause recommendation, or we call it for short NPC. That means that the investigator or the enforcement officer did not find enough information to believe there was a violation of the Kentucky civil rights law, specifically equal employment laws when it comes to employment. Now, if there was enough information to show that in fact there was a possible unlawful discrimination, that will be a PC, probable cause. So once these enforcement officers make that recommendation, and the recommendation is sent to the Board of Commissioners, and this is what I mentioned earlier, there are 11 commissioners. They meet once a month, and the meetings are open to the public, but this is a place where they make that decision to vote on the complaints investigated by the commission. And once they vote on, that will be the end of the investigation of the commission, unless the complainant requests a reconsideration. And reconsideration means that the case will be assigned to a new enforcement officer to look into any new evidence or any new information provided by the complainant. So that's just a summary of the complaint process here in the Kentucky Human Rights Commission. Again, the commission is a government agency, and we don't represent we don't represent the complainant or the respondent at this level. So if you feel that you have been discriminated against, feel free to call us. You can call us at 502-595-4024, or you can go to our website, kchr.ky.gov, or you can just send us a fax. I don't have the fax number with me, but just feel free to call us. But you can just Google us, or you go to the internet and just type Kentucky Human Rights Commission. Our service is free, but again, just keep in mind that we don't represent the complainant nor the respondent. We're a neutral agency. We are in the community. We are there to provide trainings. This training usually takes about 2 hours, where I can provide a lot examples of a lawful discrimination. So as you grow big, I understand that this conference is for businesses, especially from the minority community. So as your company grows, we encourage you to call us and ask us to come to your place of business for us to give a training. I think it's important to eradicate discrimination, lawful discrimination in the Commonwealth of Kentucky. And thank you for your attention.